presiding with Judge, the Honourable Mr. Justice Tugendhat, acting as President. The current matter before the court is the case between Open Media as applicants against the Republic of Media respondents. Each side has 45 minutes to present their case, and the court now calls for the first counsel of the applicants to come forward. Please be seated.
Yes.
Mr. President, Your Excellencies, it is an honour to appear before this court today. My name is Chin, spelled C-H-I-N, and I appear with my co-agent, Morrison, spelled M-O-R-R-I-S-O-N. We appear on behalf of the applicant. In addressing this court, I will be speaking for 22 minutes, my co-agent for 22 minutes, and we reserve 1 minute for rebuttal. In establishing the case for the applicant and establishing that the Internet Responsibility Act should be found invalid and that the First Family Privacy Act should be similarly found invalid as it is not consistent with the rights under the Universal Declaration, I will be making submissions pertaining to Orders 1 and 2, concerning firstly the collection and verification requirements under the Internet Responsibility Act, and secondly, the requirement to disclose historical location information, following information, and identification information. My co-agent will be dealing with Orders 3 and Orders 4, pertaining to, firstly, the requirement to disclose real-time location data for users of the MLM Forum, and finally, dealing with the operation of the First Family Privacy Act. Your Excellencies, turning to the first submission, it is the contention of the applicant here that the requirement to collect and verify identification data is in violation of Article 19 of the Universal Declaration, the freedom of expression. And we say this for one primary reason, the reason being that it breaches the principle of anonymity. The principle of anonymity is founded in the cases which lie in the US Supreme Court, namely the case of McIntyre and Ohio, which has affirmed the case of Talley in California. In those cases, Your Excellencies, it was decided that the principle or the ability to remain anonymous is a critical aspect of the freedom of expression. And it finds its basis in essence because the effective exercise of the freedom of expression must be as such that it can be made without fear of reprisal. As was stated in the case of McIntyre, anonymity acts as a shield from the tyranny of the majority, and it protects individuals from the retaliation and their ideas from suppression. In application to the current facts, we would submit to this court that the Mondarian people, who are of the smaller ethnicity in this ethnic conflict, who have been the subject of alleged military improprieties at the hands of the possibly the Durian people and possibly at the activities of the militaries themselves, that being in this unique position, their views and their ability to express their dissenting views has been compromised. Your Excellencies, we would submit to this court that the fact that anonymity cannot be satisfied leads to a breach via the use of the chilling effect. And where citizens who believe or are subject to the possibility that their personal information or whereabouts can be easily tracked and monitored may abstain from engaging in civic discussion. And it is on this basis that we would submit that the requirement to collect and verify identification information represents a breach of Article 19.
Now, are you saying that the collection of this information can never be justified, whatever the demands of public order and the rights of other people?
No, Mr. President. What we would submit in this case, and it may be pertinent to then turn to this issue, is the measures of the proportionality of the operation of the Act. And this turns to the third limb of the limitations test, which are outlined in the European Court, namely whether the limitation is necessary in a democratic society. Mr. President, it would be our submission in this regard, with reference to proportionality, that there are three reasons why the law in operation is not proportionate. First, the law which applies is absolute and discretionary. It does not make a distinction between users of other internet content hosts. And more generally, with reference to open media, it does not target the forums of concern, but applies broadly to the platform itself. Second, we would submit to this court that the restriction on all anonymous speech, especially speech which we would regard on the basis of the facts, specifically in paragraph 11, are speech which is representative of political expression, in that it outlines the military acting in its official capacity and outlines the activities, their alleged military improprieties, and the detaining of citizens of Mondahian race. These are clearly issues of political concern and of political expression in the current climate in the state of Bamidia. The final reason which we submit to this court that the law should be seen as disproportionate is that, subject to clarification 13, the Internet Responsibility Act has no sunset clause and is permanent in its existence in the state of Bamidia. More so, the government intends for the legislation to operate indefinitely, and in doing so, the violation of Article 19 is similarly affected in the sense that it will apply to all future periods. We do acknowledge as the applicant that there is a security threat in this case, that there are instances of bombings and the death of civilians. However, the fundamental submission in which we rest this case in Order 1 on is the fact that the law can be seen for these three reasons as being so broad, being so absolute, being so discretionary, that a finding of proportionality would not be the correct one for this court to make. Your Excellencies, if I could take this court back one step and address this second limb of that test, whether the limitation pursues a legitimate aim. It is the submission of the applicant that in the present circumstances, the facts do not support a finding that the Internet Responsibility Act targets a legitimate aim. What has been found in the case of the Human Rights Committee in Shin and the Republic of Korea is that there must be a direct and immediate connection. And if we turn to the facts of the case today, specifically in paragraph 12, the government acknowledges that there is no direct causal, but there is no direct proof of a link between open media and the bombing attacks which have been occurring. Moreover, in support of this submission, we would ask this court to note under paragraph 11 the activities which are in fact taking place in the forums of open media. Namely, that the users are documenting the military questioning and the detaining of persons. They are noting the military presence in certain locations, and they are providing discourse on military improprieties. All elements which we would submit as the applicant demonstrate that the focus of the Internet Responsibility Act does not address the concerns of national security and the prevention of such acts.
Counsel, can I ask you to help me with a problem that seems to arise from what you're saying? The proportionality judgment that it seems we may need to draw is, according to what you've said so far, between the impact of the act in chilling freedom of expression by exposing persons to the threat of reprisals if they lose anonymity. That's on one side of the balance. And on the other side, purportedly, is the danger to national security. Now, you've pointed out that there's no direct proof of the threat to national security, and you're saying that this legislation does not even pursue a legitimate aim, so we don't even get anything into that side of the balance. But on the one hand, surely there's an evident risk to national security. So I want to ask you whether it's legitimate, potentially legitimate, for the government without direct proof to respond to a risk. And on the other side, really I see nothing in the facts before us to support your suggestion, if that's what it is, that the people expressing themselves will be subject to reprisals if they lose anonymity. Where's the factual basis for that side of this balance that we're going to need to draw, according to your argument so far?
Yes, Your Excellency. Dealing with that first issue, namely, we would submit that there is a national security threat. We don't contest that point. What we would submit is that the facts, as far as we understand them in this case, demonstrate that the Internet Responsibility Act does not address this national security threat. That there can be made no link between the actions of the users of open media and the national security threat itself. And Your Excellencies, turning to that second part of
So you're saying that there is no risk that that open media will enhance the danger to national security that arises from the opposition movement, the MLM. Is that what you're saying?
In essence, Your Excellency, that is our point in one regard. Although our alternative submission, should this court decide otherwise, is that the law in the Internet Responsibility Act is not proportionate in its response if it is in fact targeting that national security threat. Thank you, Your Excellency.
If you allow me, I have another question.
Certainly, Your Excellency.
I see that you're coming to this court on behalf of open media, but also on its users. Could you please, in your presentation, specify further what are the rights allegedly violated on as concerns open media and as concerns its users?
Apologies, Your Excellency, I didn't hear the end of that question.
You appear on behalf both of open media and its users. Could you please specify in what manner their specific rights were affected? Because open media and its users may have different rights affected by the law, and I would be interested to know more about how you see them affected and in what manner violated, if so.
Yes, Your Excellency. With regards to the orders which I'm dealing with, namely Orders 1 and 2, it is in fact the submission that it's the rights of the users of open media, in Order 1 specifically, who have their freedom of expression are violated by the actions of the respondent. With regards to Orders 2, the requirement to disclose the location information, the tracking information, and the identity information. Again, it's the rights of the users and their right to privacy which have been violated. In addressing the orders of my co-agent very briefly, in Orders 3, it is a similar violation of individuals' rights. Yes, Your Excellency.
Go ahead.
Apologies. And in Order 4, Your Excellencies, it is the right of, in this case, the first family and their rights under arguably privacy concerns or security concerns against the rights of the public interest, or the public interest in that case, which is slightly different. However, Your Excellencies, if I could take this court's attention back to Order 1 and deal quickly with an argument which may be raised by the respondent regarding the margin of appreciation. The applicant does acknowledge that states do exercise a margin of appreciation in which measures they choose to address and how they address that aim. However, what should be noted by this court is that when the right in question is in fact important, the European Court has accorded the states a more limited margin of appreciation. The exercise of the freedom of expression, especially when it concerns matters of political interest, which we submit exist presently, is such a fundamental right. And this has been affirmed in the case or in the decision by the Human Rights Committee in Aduam et al. And Togo. We would submit to this court that accordingly, the right to freedom of political expression and its crucialness in the operation of a democratic society should lead this court to find that there is a very narrow margin of appreciation in this case, and when combined with the disproportionate factors which exist, would lead this court to find that the law is in fact a violation and not a justifiable derogation.
It seems to me that your entire argument rests on recognition of the user's right to anonymous speech. But why should we assume that they have an expectation of anonymity here, where the only reason that their information is kept confidential is because Open Media requires them to keep it confidential through the registration process?
Your Excellency, that delves into, in some part, to Order 2, and we'll address it in this regard. The disclosure of identification information, as has been outlined in the jurisprudence of the US Supreme Court, has stated quite clearly that the provision of that information to the government does in fact have a chilling effect on the freedom of expression. Now, we would submit that the present circumstances and such disclosure would correspondingly breach that freedom of expression.
But is there any evidence in the first instance that the users themselves have an expectation of anonymity at the time that they're signing up? Because I take note of the fact that none of the users have challenged this law on their own behalf.
Yes, Your Excellency. Dealing with that expectation of privacy issue, which I believe comes from the US Supreme Court, what we would submit in this case is that the internet represents a distinct medium. It's a different medium to the cases which apply that expectation of privacy, for instance, in the cases of Smith and Maryland. We would submit in this case specifically that the data requested, which is in addition to the identification data which can be disclosed, that represents content, or content which discloses in some degree the communications of the users. And on that basis, we would submit that there is a reasonable expectation of privacy which should be protected in this case. Your Excellencies, maybe if I turn...
So does our, in order to rule for you then, and does that mean that we have to find as a matter of law that all users of sites where there is an anonymous registration requirement are exercising their right to anonymous speech?
Your Excellency, I'm not quite clear where that question is directed at. If you could maybe repeat it.
Well, without any evidence, without any direct evidence that the users themselves are asserting their rights to anonymous speech, does that mean that we have to make that assumption in all cases where there's a registration requirement like your site has in order to find in your favor and to recognize the right that you're asserting on their behalf? Thank
you, Your Excellency. No, not necessarily. But more importantly, in this case, it should be recognised, as the circumstances and facts of this case demonstrate that there is a credible limit on the users of open media and their freedom of expression. And I apologise, Your Excellency, Judge Endicott, I realise I haven't dealt with that second part of your question maybe a while back. However, what we do submit here is that the chilling effect does occur by virtue of the Mondahian race, which is relatively suppressed, we would submit in this regard, and the disclosure of such information with regards to the Mondahian people on open media would constitute a chill on their freedom of expression.
Thank you.
Mr. President and Your Excellencies, I note that my time is fastly expiring.
I will give you 3 more minutes because you've had a lot of questions.
Thank you, Mr. President. It may be pertinent, though, even in that space of time, to go directly to the issue which we see existing in Order 2, which is the issue of whether the legislation in question, which compels the requirement or compels the disclosure of the information, of historical, of identity, and of location information, and tracking information, Your Excellencies, whether these measures can in fact be seen as prescribed by law. And we would submit to this court that they are not prescribed by law, that they do not outline with sufficient clarity the scope of the discretion imposed. They do not look at the manner of its exercise, and they do not outline the procedural safeguards or the procedural operation and the circumstances in which the information is used and stored. And we note in this case specifically, the information is in fact stored indefinitely. What has been affirmed by the European courts in this regard is that where measures taken which are essentially anticipatory, like in this case, when such measures are exercised by the executive there must be corresponding safeguards which are implemented by the government so as to prevent the abuse of power to the citizens of that country. In the present circumstances, the applicant would contend that those safeguards are not present here. We would submit that it is not clear and has not outlined the manner in which the information is used, nor the basis in terms of evidence or factual basis which would allow the government to exercise its power. In addition to that, we note that there is in fact a watch list in this case, which is opened and is available to the public. However, the case of Shimovalos in Russia has also outlined that where there is a watch list, which the government makes to allow such surveillance as is occurring in the current case, that the criteria of people who can be part of that watch list or who are on that watch list must be made available to the public so that they can foresee the application of the law and they do understand its operation in practical effect. On this basis, we would submit to this court that the justification for this legislation cannot be seen as prescribed by law, as it does not accommodate these concerns which the European Court has outlined in several cases, including Rotaro in Romania, in the case of Amman in Switzerland, in the case of Klaas in Germany, and in several other cases dealing with issues of surveillance of the nature in this question. In the alternative, Your Excellencies, and I'll deal with this issue in as brief as possible, we would submit that the corresponding concerns which were previously outlined with regards to judicial safeguards also affect the finding of this court with regards to proportionality under the third limb of the European Court's test. It may be useful here to turn to the case of Klaas in Germany itself, where it was found the exercise of an executive power, which is done in secret, in this case as it can be kept secret from the users for 180 days, that the exercise of this power requires certain elements which would allow the court to find it proportionate. And if I go to those elements themselves, it was found in Klaas that there must be factual indications of a breach or an intended breach. In that case, they had the safeguard that a written application by a minister must be done in order to begin surveillance. And it also provided general evidentiary burdens before the government could exercise that power. We would submit in the present case, and in reliance of the facts existent in the compromis, that this is not present on the face of those facts which we rely on. This is in addition to the fact, as outlined, that those procedural safeguards don't exist. And the final question which this court must then deal with is whether the national security interest in this case, which we submit is also very small and not entirely corresponding to the targeted application of the Internet Responsibility Act, but whether that national security threat can justify such broad and discretionary laws. And it is our argument that the systemic and continual breach of this, especially by the operation of Clarification 13, which is that this law will continue indefinitely into the future, would demonstrate that it is a disproportionate and unfettered use of executive power and should be found so accordingly. Mr. President and Your Excellencies, today I have made submissions concerning the first two orders, and in summary I would ask this Honourable Court to declare that the requirement to collect and verify information is a breach of Article 19 and the freedom of expression on the basis of the principle of anonymity. Furthermore, we would ask this court to find that the legislation, being broad, absolute and far-reaching, cannot be seen as either pursuing a legitimate aim or representing a proportionate response to the factual circumstances present in Bermuda today. Additionally, it is our submission that the compelled disclosure of identity, following and historical location information represents a breach of Article 12. The failure of the respondent to implement the appropriate measures to safeguard against abuse demonstrate that this requirement cannot be seen to be firstly prescribed by law, and secondly, representing a proportionate response which can be seen as necessary in a democratic society as is the state of the media. If it pleases the court, that concludes my submission, and I now hand over to my co-agent, who will deal with Orders 3 and Orders 4.
Thank you.
Mr. President, may I ask a question before Mr. Chin sits down? Mr. Chin, just on the margin of appreciation issue that you raised, you mentioned the law and practice of the European Court of Human Rights. This court is a universal court. Can you tell us how, if at all, we ought to approach the idea of a margin of appreciation differently from a regional court such as the European Court of Human Rights?
Yes, Your Excellency. There are varying tests with regard to the margin of appreciation existent in other jurisdictions. First, I would note that the Inter-American Court and the African Court have adopted the idea of margin of appreciation, but it may be more useful to turn to the jurisprudence in the US, which also outlines that the court will look at to such things as alternative measures which could have achieved the same goal which the operation is acting in, or maybe if there were alternative measures which had a lesser infringement of that right. However, it would be the submission of the applicant here that with regard to and I understand that this court is of international jurisprudence, but with regard to the heavy emphasis which the European Court has placed, and the long body of jurisprudence in that court with a margin of appreciation, that we adopt the test outlined as done so in the cases which we have referred previously.
Thank you.
May it please the court.
Yes.
May it please the court, I am Morrison, and I'm honoured to be before this Court of Universal Jurisdiction today. I will present the third and the fourth orders. For the third order, we submit that the court should declare that putting the users of the MLM Forum under secret, prolonged and potentially indefinite surveillance disproportionately breaches both their right to privacy and their right to anonymous association. I will then turn and face the fourth order, where we submit that prohibiting the publication of photographs and location information on Carla, Talia and Dahlia's tracker forums, and then requiring the deletion of all information on all of these forums, does not strike the balance referred to by you, Judge Endicott, on the one hand between the privacy of the Luskins on the one hand and the freedom of expression of the community upon the other. But first, turning back to the third order. To establish this order, I'll be making one submission on privacy and two on freedom of association. My submission on privacy, Your Excellencies, Mr. President, will be that the privacy rights of the users of the MLM Forum have been disproportionately infringed. And my submissions on freedom of association will be that the members of the MLM Forum constitute an internet-based expressive association, and both their individual and collective rights of anonymous association have been violated. And my final submission will be that that violation of associative anonymity is not proportional. But turning first to my first submission on privacy. Mr. President, Your Excellencies, all the same remarks, arguments and objections made by my co-counsel with regard to historical information and historical location information equally apply to the real-time, indefinite surveillance and secret surveillance contemplated by this order. And I adopt all of my co-agents' submissions and arguments and objections in that regard. However, I will move through and summarise the precise nature of the infringements, the legitimate aim, and the measure in democratic society for the court's benefit. First of all, regarding the infringement of privacy, if I can address a question asked by you, Your Excellency, as to who are the rights of the users at stake and whether or not Open Media was objecting on its own behalf for its own rights or the rights of the users. It's our submission that pursuant to paragraph 23 of the facts that that point is not in contention and that the open media represents the rights of all of its users, and that this is not in violation of any international principle. However, further to the submissions of my co-agent, we submit that it is the rights of the users here that are at contention, except for one area. In the freedom of association, which I'll turn to shortly, it has been held in the United States in cases like Hurley and the Irish LGBT League that the protection given to associations actually extends to those who organise and facilitate those associations. And that would be one minor difference there, Your Excellencies. However, turning back to the breach in regards to privacy, it is our submission that the close surveillance of the users of the MLM Forum in real time is that first breach. Then there is a second breach, which is the indefinite retention of their data also breaches their privacy rights. And we rely on the case of Shimovolos, which has already been submitted on by my co-agent, and also Uzen in Germany. Turning now to the issue of the legitimate aim. And in an issue which has already been touched upon by my co-agent, it is our submission that there is no evidence higher than a suspicious name to directly link the users of the MLM Forum to the MLM terrorist organisation. It is our submission that the case of Shin, already applied by my co-agent...
But don't we have to look at the legitimate aim of the legislation here, or are we looking at the legitimate aim of any particular request for reporting of data?
Mr. President, the answer is both. It's been the jurisprudence of the European Court of Human Rights, for instance, that to give effect to practical and real rights, one must look at both the measure and the legislation. And I will in fact be adopting an analysis of both in our proportionality arguments. So it is my submission that both must be adopted. And if you look here, the legislation itself, my co-agent has already submitted, is actually turned towards suppressing political dissent in our submission, although we have no direct facts on that. What we do submit, though, is that this action by the government using the legislation is moved at Open Media and one particular forum on it, and they would need to draw a link, what is called in the case of Shin and Public in the Republic of Korea, a direct link, and what is called in the case of Class, a reasonable suspicion based on evidence between that forum and the MLM. And in our submission, there are no facts. If you look at paragraph 16 of the facts, at that area it talks about the government has a suspicion, and that is all.
Just so that I'm clear, sorry, over here. Just so that I'm clear on what you're saying here, you're accepting, are you, that the level should be reasonable suspicion with of a direct link? Or are you saying it should be something different?
Thank you, Your Excellency. That's an excellent question. Our submission is that various tribunals across the world have held something different. For example, in in the Republic of Shin case, it was called a direct link. And in the case of Class, it was called a reasonable suspicion based on fact.
And so what do you say we should do?
We submit that you require some actual evidence and not a suspicion, not a coincidence, because we apprehend that the submission from the respondent will be that we have a suspicious name, that we have suspicious timing. And we would submit that there is an opposite inference available on both of those issues. For example, on a suspicious name, we submit that the way the Ushahidi platform works is that it has a broad topic at the top. In this case, it's the open Bamidia, the discussion of Bamidia. And then it arranges its forums on the basis of categories. Each of those is given another subtopic, and it then collects posts on that topic. So it's our submission that the MLM Forum is collecting posts that discuss the MLM. It's not a secret clubhouse full of terrorists, Your Excellency. And our next submission on this point is with regards to suspicious timing. It has been submitted, and it may be submitted by the respondent, that the fact that both of them appeared at the same time, the MLM sprung into existence at the same time as this forum, could be considered contemporaneous, for instance. And our submission is, well, no. Open Bamidia itself, the entire entity sprang into existence, and we submit that the entire purpose of Open Bamidia is to talk and discuss and communicate, and that purpose and topic should be imported into that forum. And that is our submission.
Isn't paragraph 16 also mentioning that the posts are empty? So is it a discussion forum, or is it a secret clubhouse?
I beg your pardon?
If you see paragraph 16, the statement indicates that it is empty, so it is certainly not a discussion forum. If it was a discussion forum, it would be full. So is it not a secret clubhouse then?
Yes, Your Excellency. We would submit that that paragraph also mentions that the posts can be turned to private. And if you turn back to paragraph 3 of the facts, it mentions that people can actually privately discuss issues within the post. And when we turn to our freedom of association submission, we will be submitting that a collective right of the association is actually that it be able to nurture, discuss, and consider a dissenting view, a view which may be unpopular, may be dangerous, and may subject them to reprisals in private. So we submit the privacy aspect of the forum is not at issue here, not a problem. What the government has to do here is prove the danger of that forum, because it's actually targeting them with an action. And then because what it's resting upon here is that that forum is the MLM, it has to provide some evidence for that. Mere suspicions are not enough. And if this court were to rule that such intrusive and grave violations of human rights can be premised on a mere suspicion, that makes a mockery of supreme and indivisible human rights in our submission, Your Excellency.
Can I just ask you another question for clarification?
Yes.
You referred to the right to association.
Yes.
Now, what you clearly said from your last answer is that the users, if there are users of the MLM site, are an association.
Yes, Your Excellency.
Are you also saying that absolutely everybody who uses open media, whether they're doing it privately, whether they have the same views, whether they have different views, whether they are arguing with each other, are also an association, or it's only the followers of a particular posting that are an association?
No, we don't submit that all the users of open media in this case are an association. We submit that the facts of this case are actually very specific on that point. And perhaps if I turn to that freedom of association argument now and return to proportionality later, it's our submission based on the US Supreme Court and European jurisprudence that an individual has a right to associate which encompasses their individual right to anonymity in the fact of their membership, their identity, and their actions within the membership. And that has been both breached and chilled by the law and the measure. Next, there is this collective right, which I'm coming to now in response to your question, Your Excellency. And there is a collective right to associate towards a common goal. And that has been called by an article of Myung Kim, The Right to Anonymous Association in Cyberspace, enclave deliberation. They're forming a discrete niche to discuss an unpopular view. Now, in our submission, the facts that makes the MLM Forum a specific association is that it forms a discrete network of individuals who have all set their posts to private. And that, in our submission, separates them from perhaps the rest of open media, because they've circled the wagons, to use United States terminology, Your Excellency, and they've created a positive impression that they regard themselves as a separate and discrete club and an association. Now, it is our submission that the authority of NAACP in Alabama has allowed that where there is a lawful objective, and we have already submitted that that is discussion of perhaps the MLM, separatism, Mondahi liberation, where there is a history of harassment. And my co-agent has already submitted how in paragraph 16 and 17 there have been allegations of torture, kidnapping, armed gangs of Duryans attacking Mondahis, that this is reasonable. And then finally, that their rights have been substantially abridged. And if I can turn to that last part in proportionality, and my proportionality arguments here address both privacy and freedom of association. Your Excellencies, Mr. President, this law creates a permanent provision which actually contemplates 24-hour surveillance, not in the sense that someone is watching 24 hours, but in the sense that the computers are always waiting, like vultures, for whenever someone should actually happen to post. Furthermore, there is no sunset clause to this legislation or to the government's action. It's indefinite. And in our submission, that abridges the policy established, the principle established in the Sunday Times and UK case and others, which is that you have to have something tailored to the objective, or it has to be the least restrictive measure possible. And for example, alternatives could have been adopted, and we suggest that alternatives could have included a warrant system to target targets. Now, I apprehend that someone might ask, how can you have a warrant system if you can't see anyone in the forum first? Well, an example of an alternate piece of legislation would be this, and this is one example. Assuming we have failed on our arguments so far and we've reached this stage, what the government could have done differently is actually used relation and link analysis to look at the traffic within the forum. And this is raised by an article by Catherine Strandberg, which is entitled Surveillance of Emergent Associations for a Network Society. Plenty of information can be derived through this method. And then people could have been targeted. The movers and the shakers, the leaders of the forum, could have been targeted, perhaps in conjunction with other surveillance. So it's in our submission here, and I adopt the submissions of my co-agent as regards safeguards, that this is too broad a brush, too indefinite, and further there's an aspect of bad faith. In the case of the military tracker surveillance, that actually took the people they wanted to surveil off a watch list. In this case, the government has spun around in the dark, seen maybe a slightly brighter light over here and taken a shot because of the topic of the forum. And in our submission, that is disproportionate.
I have a question for you.
Yes, Your Excellency.
I certainly understand your point about the significant speech interests when you're talking about political speech, dialogue about what the military is doing. But is there really a significant speech interest in simply listing the location of where troops are?
Thank you, Your Excellency. That relates really to the first order in the military tracker forum. I am submitting on the MLM forum. Would you like me to return to the first order to discuss the significant...
we don't know what's in the MLM forum, do we?
Yes, Mr. Excellency.
So to the extent that one of the requests here goes to location information, right? To the extent that this was limited to requests about location information, people who were posting about location information, would that be narrowly tailored? Would that satisfy you because that wouldn't incur upon significant political speech interests?
Your Excellency, if I understand your question, are you requesting whether just looking at someone's location and reporting on their location in the forum is okay? Or are you saying if they're just talking about the movements of the military in the forum, is that a protectable form of speech?
Yes, the latter.
The latter. Your Excellency, it's our submission they're not talking about the movement of the military in that MLM forum. It's our submission that they're addressing a topic which is actually protected under many United Nations treaties and by state practice, that is of self-determination, separatism, and the actions of the MLM toward that goal. The discussion of the military in our submission occurs on the military tracker, and this would be one other point which would actually form the disjunction between the MLM forum on the one hand and what's occurring on the military tracker on the other. There is actually no link between the people posting on those two forums, none at all on the facts. There could be people posting on both, there could be people posting on one or neither. There is no evidence of that. So it's our submission what is occurring within the MLM forum on the basis of the topic and the purpose of Open Media is discussion about the MLM, separatism and self-determination, laudable goals under United Nations edicts.
If your argument proceeds on the footing that without conceding the fact that the MLM identity on your site is not the MLM that is contemplated in para 6, then the inferences which flow are that why isn't, could you not ask a reasonable question as to, is it a squatting? And could not be a displacement of the argument that it is not a militant site, and avoid the whole question of, is it a secret club? Why is that purposive look onto the name not being initiated by Open Media?
Your Excellency, if I understand your question is, well, we can still draw an inference from the name that they may be forming a secret club. Yeah. My submission is this: if you were going to form a secret club, why would you name yourself MLM?
No, for identification of people to reach out and be co-conspirators. You could be under serious risk of being treated as a co-conspirator yourself, as an intermediary, if you had knowledge that it is MLM and it is engaged in terrorist activity or support to terrorism. You could be an abettor. So why would you not do that?
Thank you, Your Excellency. And in my submission, this forum appears empty. So if anyone had done that, they would become visible in that forum. So on our submission, on the facts, that is not occurring. Whilst that may be one inference available on the facts, we submit that there is just simply no evidence to submit that it's occurring here. Because they've actually formed a private and secret alignment of the wagons, it's actually not possible for someone who maybe wanted to join this organisation, even assuming it was a terrorist organisation. It's a private club in our submission, and they're discussing a very important issue. Your Excellency, I would love to address your question further, but I note I am running short of time and I must move to the fourth order. Turning to the fourth order, which is...
Can I just ask you a question which will impact on what you're saying? Just so that I'm clear, one of the requirements is to report the location of the members of MLM. And do you see that as an abuse of their right to privacy or of their right to association? Their location only?
With regards to privacy, their location is a breach. With regards to association, we submit that it is a breach of their individual rights to anonymity and association, and that it is a chill or an effect, what is called in NAACP in Alabama, an effective restraint on the collective right in association.
Okay,
so the
thanks.
answer,
I thought you might say that, so I'd like you to address why it's not a breach of right of privacy for the location of the first family, which you're going to come on to now.
Thank you, Your Excellency, and I'll turn straight to that right now, which is that prohibiting the publication of photographs or location information on Carla's, Dahlia's and Talia's tracker forums, and then ordering the deletion of all content on these forums does not strike a correct balance between privacy on the one hand and freedom of expression on the other. Your Excellencies, we note here the breach is not really in dispute. We accede that there has been some infringement on privacy, and the respondent have acceded that there has been some restriction of freedom of expression. But this moves again to your point, Judge Endicott. What the test we submit here is that of striking a fair balance between, on the one hand, the community's interest in a topic of general interest, which we submit are Carla and the children, their public figure status, the breadth of the measures, and also the fact of alternatives, compared against the privacy and possibly the security concerns. To establish this, I'll be making two submissions. My first submission is that it does not pursue a legitimate aim, and my second...
It does not what? Can you repeat that?
My first submission is that the First Family Privacy Act does not pursue a legitimate aim. And my second is that the government has struck a fair balance between privacy concerns and freedom of expression. Mr. President, Your Excellencies, I note my time is fast expiring, so I may have to rely upon my written submissions to establish my first submission, and I will now turn directly to proportionality. Your Excellencies, what we have here is a broad blanket measure in terms of a law, and then a direct action ordering the deletion. And I'll address both in terms of their severity. This law prevents the publication in all media, and not just on the website of Open Media. Also, this 90-day requirement has actually been used rather sneakily in our submission within the executive action to justify the removal of all content, because logically, when most of that content was posted, it was not posted above 90 days. So in our submission, this is actually not only seriously impeding the media in performing its role of communicating issues of public interest and impeded the public's right to receive issues of public interest, it's also deleted all history. It's deleted the baby with the bathwater. In our submission, turning then to the action, we submit that less restrictive measures could have been adopted. For example, we submit that only the children could have been protected because in our submission, the children and Carla are in different positions. We submit that the government could have requested geolocation tags of a high level of specificity. The Ushahidi platform is free open software, it can be modified, and we would submit that this sort of more general geolocation tag could have been requested by the government, and this would have solved all personal security and all privacy problems. Finally, there should have been exceptions for public appearances at the very least in our submission. Your Excellencies, in the very little time I have left, I must stack up the interests on either side. In our submission, Carla and the children are both public figures who generate public interest, and compared to that, in our submission, the privacy breaches against Carla were very minor. The children are in a different category, we have already agreed, but we submit that all of the photos taken of Carla and the children occurred in public, and that that is a weighing factor in this circumstance. We also submit that Carla has become a politicised figure by her relationship with Vislio, and this is in relation to the case law of Kahavara, Flinkila in Finland, and Tamar in Estonia. And that raises, Your Excellencies, I note my time is expired. May I have an extension to summarise?
You can have 1 minute.
Thank you, Mr. President. Mr. President, Your Excellencies, I'll now turn to summarise our case. In summary, this case charts the use of the internet for democratic participation and then its abuse for government repression. Your Excellencies, we submit that the first part of the case focused on anonymity and data protection, and to protect these two principles, we ask the court uphold those orders. Your Excellencies, in regard to the second part of the case, we submit that that related to political participation and the ability to hold and nurture a dissenting view, and in the case of the fourth order, to hear about issues of genuine public interest. The case is so important because it gives this court the opportunity to recognise privacy, freedom of association and freedom of expression on the internet, and to protect its relevance, to protect the future of these rights, and ultimately to protect the future of the whole world. If there are no further questions, that concludes that.
I'm a bit, I have one, Mr. President. I'm a bit lost here, because on one side you're saying everyone else deserves the right to privacy, but on the other hand you're saying the first family do not, just because of who their family are. Can you actually take us back there and tell us your particular perspective on it? Because I know we didn't have much time, but I would like to be a little more clear on your argument in terms of them being public figures.
Mr. President, may I crave an extension to answer that question?
You can answer the question.
Thank you, Mr. President. Your Excellency, your
Let's
question...
put a sunset on that, I think. Just
Your Excellency, the question you ask, as I understand it, is what is the difference between users of the MLM Forum and their privacy rights, and then Carla and her children's privacy rights on the other hand? Now that imports two separate questions. First of all, we submit that Carla and the children are public figures, whereas the people in the forum are not. And in our submission, the case law in Europe is and also in the United States, in cases like Robert Gertz and Robert Welsh, and also in Europe in cases like Flinkila and Finland, is that public figures must accept a higher level of interference. Now, it's our submission that Carla's privacy rights can be breached in this case because she's an important social figure, and Resolution 1165 in Europe suggests that can be a source of public figurdom. She is also deriving political and capital importance from Visleo, and this is through the cases of Flinkila, Kahavara and Tamer in Estonia. Finally, she has actually met a public figure, a politician, and an economic figure of importance in a context where there is political unrest, ethnic tensions, and also grumbling about the tax overhaul and reform. So not only has she, a public figure herself, got a lesser right, I beg your pardon, withdraw that, has to accept higher interference with her privacy.
do you have a legal precedent to support that?
Which aspect of that, Your Excellency?
Her meeting a public figure, or the timing of, about the fact that she was meeting a public figure at the timing of war, or etc.
Your Excellency, we would not accept that there is actually a war on foot here, but in essence, Your Excellency, we would rely on the case of Flinkila and Finland. And in that case, in the context of an affair, one of the considerations which, and the court's language was backlit its decision, was that essentially a mistress of a politician engaged in a public argument outside the home of that politician, and he was married. So the importance of the politician and the fact that she had voluntarily put herself into that situation actually cooperated to increase the level of interference she must accept.
Thank you very much.
May it please the court.
Yes, please come forward. Yes.
A very good afternoon, Your Excellencies. This is Agent Number 1, Kunal Singh, on behalf of the respondent, the Republic of Bamida, in this matter between Open Bamida and the Republic of Bamida. I will be taking up 20 minutes of this court's time, my co-agent Mr. Sourav a further 22 minutes, and we will be reserving 3 minutes for surrebuttals, Your Excellency. Now, I believe that Your Excellencies are well versed with the facts of this case, and the jurisdiction of this chamber is undisputed, and hence I seek permission to move directly to the issues raised by the applicants, Your Excellency. Now, primarily, Your Excellencies, 3 challenges have been made by my learned friends for the applicants. They've challenged the Internet Responsibility Act on grounds of freedom of speech and expression. 2, they've challenged the IRA on grounds of a violation of right to privacy. And lastly, they've challenged the First Family Privacy Act on grounds of violation of a right to freedom of speech and expression. Now, I will be responding to them on the first challenge, and my co-agent will be responding to them on the other 2 challenges, Your Excellencies. If Your Excellencies have no queries with regard to the division, I seek permission to move on to my submissions, Your Excellencies. I request Your Excellencies to please turn to page numerical 1 of our memoranda, Your Excellencies. Now, coming to my first submission, Agent humbly submits that the Internet Responsibility Act, not being violative of the freedom of speech and expression and being a reasonable restriction, is valid, Your Excellencies. Now, Article 19 of the Universal Declaration of Human Rights guarantees a right to seek and receive information through any medium, subject to certain reasonable limitations being placed on this right under Article 29, Your Excellencies. It is in light of these provisions that Agent submits that in the present case, the requirement to collect and verify identity information is 1, a reasonable restriction on the right to anonymity if there exists one in the first case on the internet. 2, that is a prior restraint which is in the interest of national security and within the state's wide margin of appreciation. And lastly, that the restriction in the present case is necessary in the interest of democracy and hence satisfies the 3-pronged test that they pointed out under the European Convention of Human Rights. First, one of the valuable aspects of the freedom of speech and expression is the right to anonymity. However, this right is one which is subject to certain limitations and can be restricted, as an individual's identity is also very much a valuable commodity for the government to identify who is responsible for certain acts in the country, as pointed out in the case of US versus Pelosi, referred to in footnote 9 of our submissions, Your Excellencies. Mr. Frank Lee Roux was a special rapporteur for the United Nations on freedom of speech and expression. He pointed out that a real name verification requirement per se, on the face of it, does not compromise this right to anonymity. In the present case, the restriction which has been imposed requiring collection and verification of identity information is hence justifiable primarily for 3 reasons. 1, anonymity, if it were to be extended to the internet, which my learned friends for the applicants have failed to point out. They've merely referred to the case of McIntyre versus Ohio, which is a case about distribution of pamphlets, campaign literature, and not extending anonymity to the internet. However, if this chamber were to believe that anonymity under freedom of speech and expression does extend to the internet, it is submitted that in this case, it is validly restricted. Anonymity, as we all know, fosters the efficacy of the internet as a tool of terrorism, as a tool for growing violence, Your Excellency, that is undebated. Secondly, it is our submission in this case that the applicants, the very moment they voluntarily reveal their identity information to a stranger web page, lose this right to anonymity, as held in the United States by the case of State versus Reed and Guest versus Lewis, as held by the European Court of Human Rights in Plon versus France, and as pointed out by eminent authors such as Professor Dirk Woerhoff, Your Excellency, that the moment such a voluntary revelation of identity information is made, an expectation of anonymity to that extent will be lost, Your Excellencies. Lastly, why such a restriction is valid in this case is primarily because it is essential to create that fine balance that the European Court mentioned in the case of Roman versus Luxembourg and the United States Supreme Court in the case of New York Times versus United States. That fine balance between this right to an individual's right to anonymity and the state's right to find out who was responsible for particular acts, Your Excellency. Hence, the restriction on anonymity in this case, if it were to extend to the internet, is justified, Your Excellency.
You're referring... Oh, sorry.
Yeah, please.
You're referring to the state's right to find out who is responsible for particular acts.
Yes, Your Excellency.
But that is not what this order is. This is saying provide us with details of every user. Why is that the state looking for the people who are responsible for particular acts?
Yes, Your Excellency. Your Excellency, if I may draw your attention to para 14A and 14D, which bring out the provisions of the Internet Responsibility Act. It is two-pronged. One, it creates a requirement for the website to collect and verify such identity information, which many websites already do, which is already happening in the case of telephone services, Your Excellency. Secondly, the revelation or the disclosure of this information is only to be made on a case-by-case basis as and when requested by the state, Your Excellencies, and not minded of all users, but only those users who have registered for a particular website, in this case, Open-Bemedia, Your Excellency, and hence have voluntarily decided to disclose their identity information, historical information, etc., to that stranger web page.
Counsel, would I be right to think that, given what you've just said about the purpose of the legislation, the effect of the legislation will be to make it impossible to use Open-Bemedia as a way of exposing abuses by the forces of the state? Is that correct?
Your Excellency, I understand that your doubt stems from various cases where such a restriction has been imposed so as to intimidate the minority into self-censorship. However, this does not satisfy such case. The present fact situations demand a response as has been propounded by the state. Now I draw your attention to the case under the European Convention of Leo versus Finland and that of Klaus versus Germany, referred to in footnotes 30 and 31. Now in these cases it was pointed out that whether a particular restriction is necessary or not is to be decided based on the circumstances prevailing in that particular state, an inquiry which is best carried out by the state, Your Excellencies. And hence, the European Convention granted a certain margin of appreciation to the states in deciding whether there existed a pressing social need and what adequate response to be tailored for that need, Your Excellencies. Now,
so we should leave it to the state of Bemedia to decide whether there's a pressing social need for a facility for publication of abuses by the forces of the states. Is that right?
No, Your Excellency. All that has been submitted is that the state is granted a wider margin of appreciation in deciding whether a particular restriction is reasonable or not. The final decision as to whether it satisfies the test lies with the European Court and various other courts, both international and regional, Your Excellencies. Now, in this case, in order to...
Before you go to the European Court to find out this balance, I think you just referred to the case of Klaus versus Germany,
Yes.
where this court has requested certain domestic remedies to be available in similar situations. Would you please explain in what manner this law would provide such safeguards for the circumstances of the case?
Yes, yeah. Now, taking Your Excellency's question of safeguards and remedies to a more normative level, rather than restricting it to the case of Klaus versus Germany, I will answer that on 3 counts, Your Excellencies. One, as I've already pointed out, that there is a certain wide margin of appreciation which is granted to the state. Second, Your Excellencies, if I may draw a parallel to various other similar legislations, Your Excellency. 2, provision 2703 of the Stored Communications Act, which again states that when it comes to non-content information, such as identity information, a mechanism of review within the Act is not really required. Similarly, under the Information and Technology Act in India, intercept under section 69A and B, it is clearly provided that the state can ask for interceptions to be made by government agencies on a case-by-case basis. In this case, Your Excellencies, one, we have not been provided with the entire statute book of Bemedia, and hence whether certain rules and regulations have been framed for guiding this particular legislation is not really clear. Second, it's pointed out that one, the IRA does not require disclosure of content information. All that it requires is a disclosure of bare minimum identity information to create a registration system. Private contents, etc. are not being disclosed. Two, it is an empowering legislation. Now, if I draw your attention to the entire scheme of acts that have been introduced in Bemedia by the state, they introduced the Military Secrets Act. In fact, they amended the Military Secrets Act. Now, in amending that, they expanded the definition of location service of military secrets. And they stated that if someone were to reveal certain military secrets, the location information of the military, that would be a violation of this act. Once a situation like this has arisen, and say a user on Open Bemedia using a pseudonym has been suspected of a violation of this right of this Military Secrets Act, how are the state to find out the identity of this user? And hence, in addition to support the Military Secrets Act, in order to create a framework where terrorists could be nabbed, Your Excellency, the requirement of an empowering legislation such as the IRA, which allows the state to create a database of identity information, and thereafter, as and when circumstances would arise, as and when there would be reasonable suspicion to which my learned friends for the applicant conceded, a revelation or a disclosure of identity information could be asked for. In fact, that the state, there has been no reported instance of any misuse of this power by the state. And if I draw your attention to a slight difference between paras 15 and 16, both requiring disclosure of information, you will notice, Your Excellencies, that under para 15, no request under para 14C for keeping this request secret for 180 days has been made. Under para 16, that request has been made. So it clearly shows that it is only in instances such as the MLM Forum, where the posts are private, where it is a secret clubhouse, probably of terrorist activities, suspected terrorist activities, that the government would require disclosure and for it to be kept secret, Your Excellency.
That's even a big statement on its own, but I want to take you back a few seconds ago to another compelling statement that you made, where you said that anonymity is an important tool for tourism and for terrorism, and you said it's undoubtful and it cannot be doubted. What is your authority on that? Because it's for such a big statement, you cannot just leave us there. You need.
I draw your attention to cases such as criminal indictment of Al-Hussein versus the United States, or to the case of Aklo, Georgia versus Miller. Now, in these cases, what happened was there were people on the internet who were inciting violence, who had opened up websites allowing people to provide
didn't
funding.
Miller cancel the law in that case? Or?
Your Excellency, the conclusions of these cases are not what I'm drawing your attention to, but the mere fact that the internet can be used as a tool for terrorism and fundraising, and that too when the internet in a state like Bemedia
so can be used as different. Can be used as different thing from as an important tool for terrorism. That's what I'm trying to draw you back to.
Yes, it is accepted, conceded, but when taken in light of the state's margin of appreciation, and a wide margin of appreciation, it becomes a valid ground for imposing a restriction. Now, if I may come to the tests in the United States and...
If I may ask about a different interest. We've been focused on the user's interest in anonymity, but another interest troubles me here, which is the Open Bemedia's interest. Through this legislation, you are effectively making them an investigative arm of the state. And shouldn't there be a burden placed on the state to show that it has made all steps in order to address the problem? And it can't be through the state's inadequacy in terms of devoting resources to investigate these different crimes, or its ineffectiveness in doing it, that it can then go and enlist the media essentially as its investigator, which may be very chilling in terms of its own relationship with its users and with its posters, and violate its own independence or sense of journalistic integrity. So what about that interest, and where do we draw the line if we allow this legislation to go forward?
Your Excellency, your question, in fact, brings me to one of the tests under both the European Convention and the United States. That is, a restriction must be proportionate. It must be least restrictive. And in this case, Your Excellencies, I draw your attention to para 7 of the facts. It states that the government did try and increase military forces. However, due to the manner in which these terrorist attacks were taking place, guerrilla activities, etc., it was unable to prevent the same. I draw your attention to para 9 and the last lines of para 9. It says that the posts on Open by Media, because of the world-class geotagging systems that are used for the website, allows us to, in fact, plot these posts on a map, Your Excellency. Now, furthermore, para 13 points to the fact that the state has already amended the Military Secrets Act. Now, despite these measures having already been taken, we see instances such as the MLM Forum propping up, all posts being private. And it is to address such activities that it is believed, and it is our submission, that only a system rooted in a real name verification requirement, which, yes, it does place a responsibility on the website to collect and verify the information, is clearly necessary in the interest of national security, Your Excellency, taking into account the fact that, as in the cases of Surek versus Turkey and Haji Nastasia versus Greece, decided by the European Court, there have been instances of violence between the two ethnic communities. The state's political independence has been undermined. Armed militia has come up, attacking both Didians and Mondahis. It is not an ethnic question, but one of terrorism. There is a situation where we are effectively leading up to a case where there will soon be a demand for secession, independence. Para 5 points to the fact that the private grumblings have now grown into grumblings for independence by Mondahi politicians. Hence, it clearly shows that due to the sensitive condition of the political affairs in Bamidia, it becomes very necessary that the state be given a wider margin of appreciation, as it was in Surek and Haji Nastasia, to impose restrictions on the freedom of speech and expression, Your Excellency. In fact, reasonable restrictions. If Your Excellency is satisfied, and if I may be allowed to very briefly sum up as to why these restrictions are reasonable, both in the United States and the European Convention, I'll proceed, Your Excellencies.
If you're doing that, can you also cover why there's no sunset provision? Because a great deal was made of that by counsel on the other side.
Yes, Your Excellency. Now, it is submitted that in the case of Schlek versus Ukraine by the European Court of Human Rights, it was stated that Article 10 of the European Convention imposes a responsibility on the state to create a regulatory framework for the application of freedom of speech and expression on the internet. And hence, this law, 1, it is in the interest of national security, and 2, to provide a regulatory framework for the internet as such, and to regulate freedom of speech and expression on the internet as such, which is not restricted to the circumstances existing now, which goes well beyond that. And hence, no sunset provision, Your Excellencies. The respondent believes that such a sunset provision in this case is clearly not the requirement, Your Excellencies.
So it's your submission that it is always in the interest, and always will be in the interest of national security, that the government be able to access the name of every person who ever uses the internet?
Your Excellency, like I pointed out before, and at the cost of being slightly repetitive, I point out that this is not a case where the government will have access to the names of all persons of Bamidia, or all citizens of Bamidia, or all persons working in Bamidia. It is only the case where users of website, that is, people who decide to post on a particular website, and not users who merely decide to view something on a website, will come under government surveillance. And as the legislation in various countries suggest, as Claus versus Federal Republic of Germany suggests, such restrictions are in fact valid, Your Excellency.
You've had a lot of questions, and
Yes.
your time is up, but I'll give you another 30 seconds just to sum up what you want
Much
to
obliged, Your Excellency. Just to sum up my last contention on reasonableness, it is submitted that for a restriction to be reasonable in the United States, there must be a clear and present danger, as elucidated by Justice Oliver Wendell Holmes in Schenck versus United States. Under the European Convention, there must be a pressing social need. Now, in both these instances, because of the factual circumstances that I've pointed out, the provocative insults, the provocative posts, etc., because they incite racial hatred and because they incite a threat to national security, constitute political hate speech, which in this case can be reasonably restricted, taking into account that the state does have a broad margin of appreciation, Your Excellencies.
Thank you.
If Your Excellencies have no further queries, I'd like to call on my co-agent to deal with his submissions. It has in fact been a pleasure to argue in front of us.
A very good afternoon, Your Excellencies. This is Agent number 2 appearing on behalf of the state in the matter relating to Open Bamidia versus the Republic of Bamidia. The agent has primarily 2 contentions to make, both of which pertain to the right to privacy. The first of those contentions is that the right to privacy of the applicant's users in the instant matter has not been violated. Under this contention, the respondent primarily will submit in 3 limbs. Firstly, that there exists a situation of public emergency and a state be allowed to derogate from its obligations. In the alternative, the agent will submit that there is no reasonable expectation of privacy of the users in the instant matter. In the alternative, should the court hold that there is a reasonable expectation of privacy on the part of the users, the agent will submit that the restrictions in the instant matter are necessary and proportionate. If that explains the scheme of the presentation today, the agent will move on to the first submission with regard to the public emergency. Your Excellencies, if I may now draw your attention to footnotes 86, 87, and 89 of our written submissions on numerical page 12. Your Excellencies, in the absence of the definition of public emergency in the Covenant on Civil and Political Rights, as well as the ECHR statute, we shall primarily rely on judicial decisions given in this regard. Your Excellencies, in the decision of Brannigan and McBride versus United Kingdom, as well as Lawless versus Ireland, the court held that for proving a public emergency, it must be established that an exceptional crisis has gripped the entire population. In the same cases, it was held that the court must be satisfied that all other existing measures taken by the state have failed. Existence of a secret militia inciting or committing crimes proves prima facie before the court that there exists a public emergency. Your Excellencies, in the instant matter, all the requirements are satisfied. There is the existence of a secret militia called the MLM. There's also a very strong suspicion that the activities on the internet and the activities of the secret militia are connected. We have taken all sorts of measures, including amending the military secrets law, and added the IRA only as a measure of last resort. Therefore, I urge this court to believe that the state be allowed to derogate from its obligations and take certain decisions and make laws which are needed in the interest of the country by affording it a wide margin of appreciation. However, should this court believe that the state should not be allowed to derogate, then it is my submission here that the users have waived their reasonable expectation of privacy. Your Excellencies, if I may draw your attention to the case of Malone versus United Kingdom, as well as the US decision in Katz versus United States, a prerequisite for establishing the right to privacy is that a person must have a subjective satisfaction of privacy. Your Excellencies, if I may now draw your attention to the famous US decision of United States versus Miller. In that case, the court held that where a person voluntarily discloses certain information to a third party, the reasonable expectation of privacy goes down. In the instant matter, therefore, people have voluntarily subscribed to the website by giving certain information about them, which includes their geolocation tracking, because this is a tracker forum. Hence, Your Excellencies, their subjective expectation of privacy does not exist, and they have waived their subjective expectation of privacy. Should that, if Your Excellency...
Counsel, I'm sorry to interrupt in a way, because my question is about the basis for referring us to the United States law. Why would it help us in applying the Universal Declaration to know how the American judges have interpreted what their founding fathers did in constructing a constitution for that country? Can you help us? Why would American law even be helpful in deciding what the extent of the right is under the Universal Declaration?
Your Excellencies, I do understand that there is a difference in standard in the way American judges have interpreted the Fourth Amendment, and there's a difference in the way right to privacy has been viewed by the European Court. In a sense, in the American jurisprudence, there is the test of the subjective as well as the objective test of reasonable expectation and whether the society considers it reasonable. And in the European Court, there's a test of necessity and proportionality. However, Your Excellencies, I would draw your attention to the fact that both of the jurisprudence in Europe and America stress on the fact that it has to be established that there is an actual subjective expectation of privacy. And I was only citing the decision in US versus Miller to state that where a third party has been given certain information voluntarily by a user, that subjective expectation of privacy is lost. However, Your Excellencies, if this court is not persuaded by the fact that this decision should bind this court, then I submit that within the domain of the Universal Declaration of Human Rights...
But even if, sorry to interrupt again, but even if we are convinced with the decision in Miller, I still don't see the applicability, because in Miller there's a risk factor that was produced, and which you need to explain to us how reasonably that user of it is expecting that. And there's the subjective expectation of privacy, and there's the issue of voluntarity. You are not really given them much chance here in this particular situation. Why not just do that to all internet users in the country?
Your Excellencies, first of all, Open Media is a tracker forum where the geolocation is tagged. So
there's a popular website at the same time.
Definitely, Your Excellencies. And therefore, when someone makes a post on Open Media, the person voluntarily subjects himself or herself to be geolocationally tagged. With regard to the fact...
But not knowing where that information is going, do they?
No, Your Excellencies.
Because they are assuming that it is a two-way line, if I'm not mistaken.
Your Excellencies, they might not know where that information is going, but to the extent that they have supplied that information or that information is made public to the third party, which is a website in the instant matter, they have waived their subjective expectation of the right to privacy. It's no longer private. It's a matter that's already there in the private domain, which is why they have waived it to the extent that they voluntarily chose to post on the website. However, Your Excellencies, if the court is not satisfied that they should be persuaded by this decision of the United States Supreme Court, I will establish that under the Universal Declaration of Human Rights, as well as under the ECHR statute, the measures are necessary and proportionate. Now, Your Excellencies, in a series of decisions, which includes Krustlin versus France, as well as the much-quoted decision of Klaas versus Federal Republic of Germany, the court has held that a threefold requirement must be satisfied to establish that restriction is reasonable. First, the restriction must have legitimate aims. Secondly, the restriction must be necessary in the context of a democratic society. There must be a compelling need. And thirdly, the restriction must ensure that it is lawful and as per law. Your Excellencies, before I move on to establishing that all the requirements are satisfied, let me briefly elucidate before the court as to what is the purpose of the Internet Responsibility Act.
Counsel, I'm sorry to interrupt you. When you refer to reasonable expectation of privacy, are you in fact telling us that any user that wishes to limit the information provided by him is equally trusting open the media and the government and the remaining users in a limited circle of exchange of information. Are you telling us that any such user is to be expected to have a reasonable, is to be seen as having an equal reasonable expectation to privacy in comparison to all these parties?
Your Excellency, my only statement is this, that once a user knows that this is a tracker forum which tags a geolocation, and the user chooses to post on such a tracker forum by voluntarily disclosing information about identity, website, other requirements that the website has, then to the extent that the information has been disclosed voluntarily, the subjective expectation of privacy on the part of the user is lost. That's my submission, Your Excellency.
Under the same logic, could you require all cell phone users in the country to collect information about the location of the users and also to monitor their phone calls under the logic that if somebody chooses to buy a cell phone and to use a cell phone, that they're subjecting themselves to that and voluntarily waiving their rights?
Your Excellency, if I may point out two differences between the example that's been cited by Your Excellency. First of all, with regard to mobile phones, anyways around legislations across the world, the particular location of the mobile tower in which the call was made can anyways be revealed to the government. With regard to the content of the telephone conversation, that cannot be interfered with by the government, and in the instance statute itself, we have left out the content of the information. If the statute were to regulate content as well, we would not be standing here before this court and justifying that it is reasonable and proportionate. If Your Excellencies permit me...
But you are asking for content and of some other forums as well here, yeah?
Your Excellency, we have not sought the content of any information. Your Excellency, the scheme of the Internet Responsibility Act is only this, that it only permits the government to identify certain users. The Internet Responsibility Act is not a penal statute for users. There's no penalty for the users under the Internet Responsibility Act. What we are trying to do very simply is this. We have a specific watch list of people we suspect of indulging in terrorist activities. We have exhausted all our resources in finding out who they are. Now there's a website which geolocates certain people. Now if it so happens that there's a suspicious posting on the website, and from the website we know the identity of a person, the address, and where the post was posted from, and compare it with our watch list, we can go and nab that person. And if it so happens that the person has indulged in commission of a crime, then we can prosecute them under the ordinary laws of land, and they will be entitled to all sorts of protection that the penal statute has. The entire purpose of this statute is only restricted to identifying people and not punishing people.
But Counsel, the Act goes further than that, doesn't it? Because it allows you to request the details of any user without giving any justification.
Your Excellency,
you've explained how you might use it, but that's not how the legislation is framed. Is that right?
Your Excellency, the request will be made on a case-to-case basis. And if paragraphs 15 and 16 are any pointers to the way this has been used, so far this has only been used with regard to the people on whom the government has a strong suspicion. Also, I would point out, Your Excellencies, that I do understand that this court might be feeling that there is an incessant need for some sort of a judicial review. And I will draw your attention to the very curious provision of Section 2703 of the Stored Communications Act in the United States. Now, the provision very curiously speaks about a judicial inquiry, speaks about obtaining a warrant by means of federal rules of criminal procedure on the one hand, and the second paragraph of that section says there is no need to obtain warrant according to the federal rules of criminal procedure. Well, the natural question that arises is, what is the line of distinction? Well, the line of distinction is only this, that under the former, the government can access the content of electronic or wired communication, while under the latter, in which there is no need of judicial review, the government can only seek non-content information, which is only identifying certain people. And that's what we precisely want to do here. By means of a statute, we want to identify certain people. If they have violated the military secrets law, we'll prosecute them under that law. If they violated a terrorist legislation, we'll prosecute them under that law. And that too on a case-to-case basis. There's no presumption of bad faith on the part of the government to state that we will target people and hunt them down by means of the Internet Responsibility Act. This does not contain a single penal provision with regard to any of the users. This only serves the purpose of identifying people, comparing them to our watch list, and seeing if they can be prosecuted under the ordinary penal laws of this country. Your Excellencies, I will now move on to stating that this law is supporting a legitimate aim and there is a compelling need. Your Excellencies, as a matter of fact, national security is a legitimate aim according to Article 29.2 of the Universal Declaration of Human Rights, as well as 19.3b of the International Covenant on Civil and Political Rights. Your Excellency, all that we need to establish, therefore, is a direct connection between the restriction and what we seek to achieve by it. Your Excellency, my co-agent has already drawn your attention to the fact that there are private forums about which we have no information. Therefore, the direct link in between what we purport to achieve is to find out some information about these forums. And once we do, it will only help us in improving not just our national security concern, but will ensure that only those who are guilty are punished, and therefore the ethnic tension in between the communities will also come down. These are the three legitimate aims that the Internet Responsibility Act supports. Your Excellencies, I will also submit that there is a compelling need, and the measures are least restrictive. The reason why I say it's a compelling need is because we have exhausted all our measures, including amending the Military Secrets Law. And this law was promulgated only after all sorts of measures were taken. Now just imagine if there were a contention that the Military Secrets Law is in fact enough to take care of the situation. I will illustrate how it's not. Your Excellencies, now we have a law which prevents the dissemination of information about the location of the military, which is the Military Secrets Law. But what if someone violates the Military Secrets Law and still reveals the location of the military? How do we know where the person is?
Why is it a secret, just any information about the location of military personnel?
Your Excellencies, because if I may draw your attention to paragraph 12 of the fact sheet, in light of the severe ethnic tension and emergency that exists, in two separate instances, government attempts to prevent bombing attacks have failed, even though the government was acting on solid information about the likely target. Marketplaces have been bombed. A parliamentarian has been killed. There is a severe ethnic tension, which includes the existence of two secret militia, and government efforts are being foiled time and time again because the real-time location of the military is being disclosed. Therefore, we brought the Military Secrets Law, the amendment to the law, and now we need to aid that statute by means of the Internet Responsibility Act so that we can identify those people who are violating the provisions of any of the penal laws of this country. If Your Excellencies are satisfied, I have a submission to make with regard to the First Family Privacy Act.
Yes.
Your Excellencies, my learned friends on behalf of Open Media have very rightly conceded, and we accept 2 points with regard to this submission. One, that there has been some infringement on the right to privacy of the First Lady and her 2 minor children. And secondly, they have also conceded that if it were to be a law concerning the 2 minor children, both of whom are aged 8 and 10, then they would probably not have any problem with this legislation. Your Excellencies, therefore, that only leaves us with the question of proportionality and whether the restriction is valid. If there is no debate on the fact that the cause that's making the state deliberate upon the legislation is a cause that is valid, which means that there has been an infringement of privacy, I will establish before the court as to why the restriction on freedom of speech and expression is proportionate.
Well, what exactly is the basis for this statute? It's called the First Family Privacy Act, but I understand that the government enacted it on the basis of security concerns as opposed to privacy concerns.
Your Excellencies, I do understand that there was a very important security threat that was facing the First Family as well. However, my plea is strictly this, that their right to privacy was also sacrificed. And here I'll make a point regarding the fact that it is in the context of privacy that we've brought the legislation, besides the security concerns that might exist.
Well, assuming that the legislature enacted it on the basis of security concerns, can we uphold the legislation on the basis of privacy concerns?
Your Excellencies, the legislation has not merely been drafted with regard to the security concerns. In fact, their exposure to public scrutiny and the way the posts have dealt with their private life enhances their security concerns, and therefore there's a direct correlation in between sacrificing their security interest and sacrificing the right to privacy which is involved in the matter. It's not a black and white case, but there are shades of grey that concerns us in the instant matter on that point, Your Excellency. If Your Excellencies permit me, I will submit before this court that there has been a decision in von Hanover versus Germany in which the court said two things. Firstly, that even in public places there is a reasonable expectation of privacy, and even public figures within their private domain are entitled to a right to privacy. So definitely it's not the case anymore that public figures have abrogated their right to privacy. Your Excellencies, it is also the case, as per the decision in KU versus Finland, that minors are entitled to a greater protection of law under the Convention for Rights of Minors, as well as under the decisions of the European Court of Human Rights. Your Excellencies, that being the legitimate aim, and my opponents having conceded to the fact that there has been some sort of infringement, I will tell you how the infringement is proportionate. Your Excellencies, may I draw your attention to paragraph 20 of the fact sheet. It says, the law specifically excludes the location information whose accuracy permits only a determination of the city or a larger geographical region. Your Excellency, therefore, this does not choke or cause a chilling effect. If I were to make a post saying that the First Lady is in London meeting X, that sort of publication would still be valid. What would not be valid is if I said the First Lady is in London and she's meeting someone at Harrods Knights Bridge. Your Excellency, the law has specifically included information about the location whose accuracy permits the determination up to the extent of a city. Therefore, as long as activities are going on, and I want to report them with respect to which city the activities are going on and what the activity is, that is still permissible under the First Family Privacy Act. What is not permissible is the over-intrusiveness of the media glare and glare of the general public into the private affairs. And if I may draw your attention to paragraph 18.
Why should the law be so wide as to prohibit the publication of the fact that the family has gone on holiday at a particular time in a particular place?
Your Excellency, if I were to report that the family is holidaying Mauritius, for instance, it is still allowed under the First Family Privacy Act because the geographical location is a city or anything larger than the city. What is not permitted is if I said that the family is right now in the beach in Mauritius and there are friends that have joined the family. Your Excellency, therefore, it does not choke or chill the effect of speech. What it does is impose only a reasonable restriction. And surely, Your Excellencies will believe that there is no general interest in knowing whether Talia has fish but no dessert in her dinner.
But you have a provision about picture taking, no?
Yes, Your Excellencies.
And what if a picture reveals where they are? What's your...
Your Excellencies, we have banned the publication of pictures under the First Family Privacy Act for the principal reason that pictures have a greater effect on the minds of the people and they make the information more verifiable. So if...
Can I argue that point on its own for a little bit? Because on one side you're arguing earlier on the application of reasonable expectation of privacy, but and you used Miller as the authority, but can't we argue by that same virtue that the First Family Privacy Act, or Protection Act as I would like to call it, that it's actually that the First Family, they don't, from the date that he stood for elections to become Prime Minister, they gave their consent or waiver to that right to privacy. They became public figures and automatically a lot of what they do is public interest, specifically in what you referred to earlier as a time of ethnic tension or political unrest.
If Your Excellencies may permit me, I have exceeded my time.
You answer the question and then I'll give you 30 seconds, and I mean 30 seconds, just to close your presentation.
I'll answer the question Your Excellency has posted. Your Excellency, in the case of Miller, it concerned a case where there was a voluntary disclosure to a third party.
But isn't the husband standing for elections a voluntary disclosure?
Your Excellencies, in the case of von Hanover versus Germany, in which Princess Caroline's family was photographed as skiing it was held that it is not in the legitimate interest of the society that people of Monaco
And
have
it was
to know.
public curiosity as opposed to public interest.
Yes, Your Excellency. And there was a test of newsworthiness that was laid down and said that inside the pub, if they've been photographed in a public place, it doesn't necessarily mean that it is not within their private domain.
But doesn't the fact that it's a political unrest period give it a virtue of that there is public interest in that case and newsworthiness? And
Yes.
Hanover too is a good example, I guess.
Your Excellencies, in fact, that's a,
Just adding to my learned colleague's question, you're in fact aware that both in both judgments of Van Hanover, the court pointed out also that the assessment is made on a case-to-case basis.
Yes, Your Excellency.
And it seems that your law is imposing an overall prohibition.
yes, Your Excellency. If I may be allowed to answer both the questions with prior permission of this chamber. Your Excellencies, first of all, I do understand that in light of the ethnic tension, there needs to be some matters reported about the first family. Your Excellencies, that is anyways permitted because the reporting of matters is not being barred by the first family privacy act.
Pictures would.
Your Excellencies,
If I have a picture of Carla having dinner with her boyfriend on the same day as this political unrest, it's important to me. And I think we've had a lot of recent cases that are authorities that serve as authorities for that.
Your Excellencies, if I may just use the example of Von Hanover II. Your Excellencies, in that particular case, the article concerned the health of Princess Raina, who's a very important public figure in Monaco. If it's a matter as important as that, then definitely it would warrant a discussion because it's in general public interest. However, in the instant matter, it has also taken into account silly things like where she's been having dinner and what she's been having for dinner. Your Excellencies, I do understand that there is a very important interest in dissemination of information. All I am saying is that dissemination of information is allowed. I can say that the First Lady met so-and-so in the City of London. What I cannot say is that the First Lady, while meeting so-and-so, had this and this and published a photograph. And with regard to the photograph, the reason why we have an objection to it is because the effects of an audio-visual news is in fact much more than how it appears in print. And therefore, if I said that Talia and Carla are right now, say at the London Eye, it would in fact expose them to a greater threat of invasion of privacy and security in light of these ethnic times.
Yeah, I think I was stop there answering the questions. You can have 15 seconds now just to tell us what you really want us to be left with.
Your Excellencies, I will only summarize before this court by saying that in light of the fact that there is a very important national security threat, the state in good faith must be allowed to impose the restrictions which are anyways reasonable and non-arbitrary. And with regard to the First Family Privacy Act, I will only submit before this court that the Act only imposes a reasonable restriction without chilling speech. On that count, I would like to rest my case. It's been a pleasure arguing before this honourable bench.
Now, who is speaking for the applicant in rebuttal?
Mr. President and Your Excellencies, we have one point to make in rebuttal. And the point concerns what this court must do in weighing up proportionality. And it should not take the respondent's argument that the exercise of power has, to this point, according to paragraph 15 and 16, been done reasonably and in a manner which is compatible with the Universal Declarations. What this court must look to is the operation of the Internet Responsibility Act in practice, and the fact that the legislation here makes quite clear that there is discretionary power, that there is no evidence or criteria provided in this legislation to guide the exercise of this power. And it is without such safeguards that the applicant would seek that this court find that the actual operation of the Internet Responsibility Act is not proportionate, even with and acknowledging some degree of margin of appreciation. May it please the court.
Your Excellencies, the only point of surrebuttal is with regard to how the Act operates in practice, and I had reserved 3 minutes for the surrebuttal. Your Excellencies, I do understand that a discretionary power has been granted to the state. Discretionary power to do what? To collect information. This is not a penal statute which imposes criminal sanctions on the users. Discretionary power to collect information when? Only to collect information on a case-to-case basis. The government is not a repository of all information, and the government is definitely not doing a state surveillance here. All we are seeking to do under the Internet Responsibility Act is that even in these dangerous times that surround the country, we're leaving out the content of information. That's why it's least restrictive. It is proportionate because all we are seeking to do is identify certain users.
Counsel, doing that identification, given everything you've just said, that will make it more difficult for open media to expose abuses by the state forces, I think. Now, tell me if you would agree with that, and then how are we to decide, granted that the Internet Responsibility Act will help the forces of the state to fight terrorism, how are we to pick between these two?
Your Excellencies, first of all, I submit that the Internet Responsibility Act will not make sure that people don't complain about military abuses. Now, should it so happen that there is a post on open media and we find an information about a particular user and we track the person down, well, we have to prosecute them under the ordinary laws of the land. And if it so happens that the person has not committed any crime, or if it so happens that we illegally detain such a person, that detention will fail according to the ordinary penal laws. With regard to how the Internet Responsibility Act solves the military problem, Your Excellencies, I'll just give you one of the numerous instances. Now, the military secrets law after the amendment provides that you cannot disclose information about the location of the military. Suppose there's a violation of this law on the website. All we need to do is find out from the website who the person is, what the person's address is, and where historically has the person posted from. And we can immediately go there and arrest that person, prosecute them under the ordinary laws of the land, and make sure all protections, including the right to liberty, right to free and fair trial, under all. So the only thing that the Internet Responsibility Act is, in fact, aid all our anti-terrorist legislations and ordinary laws of the land in finding out in quick time. You would have to, at this moment, realize that we are having military activities, and there's no scope that the state can strain its resources any further. And therefore, we have to find the quickest of ways in order to have access to criminals and those who break the law and those who are terrorists. And that's what the IRA seems to do, and that's the reason why the IRA should be regarded as a valid legislation by this court today. If that satisfies Your Excellency's question.
Thank you.
The Council, on behalf of the state, would like to rest its case. It's again been a pleasure arguing before this court.
Kept you waiting for a little while, and the reason is that you've set us a difficult task. I'd like to congratulate everybody for the difficulty of the task that you have set us. What we are now going to do is we're going to make some observations on the teams and the speakers that we've heard. We're going to announce then the best oralist for the final, and then we're going to announce the winning team. So we're going to start with some comments. Would you like to start?
So I was the quietest, I guess, when we were asking the questions, because I was writing a lot of notes here, and I thought I'll share them with you. And some of them are going to be positive, and some of them are going to be negative, but hopefully constructive for future moots and future borrowing. Applicant 1, Mr. Chen, I actually really enjoyed your presentation skills. You spoke very slowly and clearly. You had great eye contact. You made sure at every point you looked at one of us, so that was a really good skill of yours. The move back to your argument was very good as well. So once we throw you off with a question, the way you swiftly and smoothly go back to your argument was very good, so you didn't look like you were thrown off. One hopefully constructive criticism I'll give you is that you did not refer us enough times to the memorial, to the written document, and by referring us to it could help you do two things. One, making sure that we're on the same point that you were on, and two, you could buy time when you want to think about your next point. A couple of times you were lost in a way and didn't know where to start again from. By referring us to a document, you're keeping us busy and finding a good place for you. But I personally really enjoyed your presentation. Mr. Morrison, you had good reference, because when you started, you actually referred us back to the question that your colleague didn't answer. That was a very good way of starting your argument, and a very good memory for those judges that didn't forget that their question wasn't answered. So that was extraordinary. You did very well in in responding to the questions. We didn't throw you off by our questions, but unfortunately you were thrown off by time more than you were thrown off by difficult questions from some of the judges. So whilst Dean Timothy would have asked you a really difficult question, or I asked you a difficult question, you were still very calm and able to answer it. You were still anxious whenever you looked at the time. And although you were anxious about it, it threw you off, as opposed to make you restructure your argument in a quicker way. So that would be one negative thing I would point out. The other thing was, I personally wouldn't dare, and I come from a jurisdiction where the judge is the only person that speaks in the name of the king, and I think it's pretty much the same thing in most of places in the world. But I wouldn't dare to say to a judge, that was an excellent question. I don't think the judge is waiting for the counsel to tell him if he liked his question or not. So that I would avoid that, and I would avoid a lot I think a lot of people in this room have heard my story of my first day on court when I was sent back home for simply having gel in my hair. So I personally am too scared of a judge to tell him that he asked a good question. But all in all, your presentation skills were really good, and you had good responses, and that's very important in mooting. Respondents, Mr. Singh. And I think I'm going to be more harsher on the respondents because I've seen them before, I've judged them before, and so I actually have seen some development there. Mr. Singh, I think you were very well spoken. You were very professional and had good hand gestures, as opposed to your colleague there that you can learn from. Your eye contact wasn't that great. You concentrated on your area of comfort. So you found it comfortable to look at John and myself and stayed there. You need to move your eyes around, I think. There's many more people here, a lot more important people than myself and John, trust me. Drawing our attention to the memo and the fact sheet was very useful. Again, it's a good skill because it buys you some time and it makes sure that we're on the same wavelength. When you're using authorities, I would say you need to be very careful to know the authority in and out, because sometimes you will have a judge who's judging you on the moot who actually judged the case itself or was a representative of the case. And I think you've had that experience with some of the QCs yesterday. So just in case, when you use an authority, make sure that that you know it more than anything in the world. Otherwise, don't use it. But it was good that you were cautious as well of being repetitive. You pointed it out because at some point one of us would have pointed it out. Don't use statements like this cannot be doubted or no one can doubt this, because general statements like those, you will be grilled for them. So just generally speaking. Respondent number 2, Roy, I think you were a good presenter. You were well spoken and clear. You acted nervous when you're thrown off by a hard question. There's a saying that a lot of, I think the judges will not like, but I personally, coming from an in-house environment, could get away saying that a good lawyer worries a lot about the fact, but the great lawyer worries about how they present them. And I think in your case, you knew the facts very well, you knew your argument, your structure was amazing, but the way you presented it was missing at certain points because you were thrown off by the question. You looked nervous for 3 seconds, then you would answer it. So that nervous look, you should lose it somehow. When you ask you a question, you need to understand that sometimes when we ask you a question, we're actually on your side. So my question was actually leading you towards a fact that I needed you to present. So don't assume. I know in the Indian moots, a lot of times you get grilled by the judges, but sometimes the judges is actually helping you because they want you, one, to present the point that you want to leave the rest of the judges with, but two, maybe they want you to move on. We understand that fact and we need you to move on. But generally you did good research and you were good in sending us back to read, very similar to your colleague in sending us back to read the memo. But all in all, I really enjoyed this final. This is my 3rd final, and to be honest, it was the best one I've had so far. So you've done very well. You should be very proud of yourselves, all of you.
This is, I think, the 3rd year in which I've come to judge the final, and I've done so because it gives me great pleasure, and this year it did too. All of you were fluent, all of you were confident, and no doubt that's why you've reached the final. But all of you have got a lot to learn. Advocacy is about persuading the court, and that requires good eye contact with the judges, and when you've got a big court like this, that's difficult, but you need to keep your eye on your judges to see how they're reacting. You mustn't be too assertive, because that is off-putting for a judge, just as excessive deference is off-putting. That's something you have to gauge. But none of you had too much trouble with that. The points where I'd say that all of you could be criticized, not conceding the weak points. If you want to persuade a judge that you're worth listening to, it's a very good idea that the judge should recognize, that you recognize, the weakest points. And legitimate aim was not a strong point for the applicants in this case, and margin of appreciation was not a strong point for the respondents in this case. You need also to focus on your best points. Obviously, for an advocate, it's easy to say that, but the best point is the best points that the judge think are the best points, so it's not very easy for the advocates to know which are the best points, but you've got to take a chance on it. The facts, all litigation really is about facts, not about principles. Principles come in because they're attached to facts. And all of you could have focused much more on the facts of this case. There were quite a lot of facts in the sheets that we were given, to which nobody referred at all. So I would I would urge you to concentrate on the facts. You were all good with questions in the sense that none of you were put off. A lot of inexperienced advocates, when faced with a question, simply don't know what to say at all because they're too nervous or they're not agile enough in their thinking. None of you fell down in that way, but when you are asked a question, the judge usually wants a short and precise answer and not a lengthy one. Although you were all very good at picking up on questions, you were all a little bit too lengthy in your answers. But you were all very good. You've given us a very hard task, and the last thing that I would want any of you to go away from this room feeling is that we didn't think that it wasn't a very close run thing for both the results that we're going to announce. It was a very close run indeed for both of them. And now, the first announcement is of the best oralist for the final, and we have decided to announce that the winner of that is Mr. Silas Morrison. And the winning team is the NALSAR University of Law, Hyderbad. Thank you very much.